Hi, I'm Tom Fitton, President of Judicial Watch, with our weekly update live here on Facebook Live. Thanks for joining us this week. It's a busy week. I'm looking at my notes here. There's a bunch of things to talk about. New Judicial Watch lawsuits, confirmation of illegal surveillance of President Trump's team on his way into the presidency. And one of those new lawsuits involves also violations of law by Hillary Clinton and the failure of both the Obama administration and now arguably the Trump administration to do what is necessary under law to rectify that situation. But a lot to talk about. First up this week is the revelation by the House Intelligence Chairman, Mr. Nunes, who disclosed to the American people just yesterday, the day before yesterday, that President Trump and his team were indeed surveilled by the Obama administration, and that surveillance was widely distributed in a way that was arguably inappropriate. And this is what I think happened, based reading between the lines of what Mr. Nunes said, is that they were listening in on conversations that picked up conversations of either Trump or his close advisors after the election. And that information under the law and regulations is supposed to be minimized. So if there, let's say you call up the Israeli ambassador and your name pops up in intelligence gathering of as they're surveilling the ambassador's phones, you are supposed to, that your name is supposed to be private, unless unmasking your name is important to the development of that intelligence and allowing others in the government to understand what that intelligence is about. Well, Nunes looked at this material and he realized, material which, by the way, was brought to him by a whistleblower, that these names were being picked up, these conversations were being picked up, and these people were being unmasked, meaning their privacy was being violated in inappropriate ways. So you didn't need to know about these names or these communications involving President Trump perhaps directly and his people. And this would have been a major violation of law if this occurred. And we also know, obviously, that some of this material was leaked. We know the conversations with the Russian ambassador that General Flynn had, that surveillance was leaked, which is wildly illegal. So now we have confirmation that President Trump was in the ballpark when he complained about Obama wiretapping his phones. It looks to me like they were surveilling the Trump people and just spreading it all around like gossip in the Trump administration or the Obama administration. And there's got to be a grand jury impaneled. I would suggest a special prosecutor's in order, because you can bet Jeff Sessions is one of the officials who was being improperly monitored here. And if I were President Trump, I'd get all this information out to the public as soon as we can. Obviously, we've got our own litigation that we're pursuing. We have Freedom of Information Act requests pending. And we're not going to wait for Congress to tell us what really went on here. We're going to file our own Freedom of Information Act request. We have over a dozen pending. We have 2 lawsuits pending on issues related to this. So we're not going to wait. But in the meantime, we're going to pressure the Congress to do the right thing, obviously, because they need to conduct oversight. And hopefully President Trump or his appointees will understand that the FOIA law, it's important that they enforce the FOIA law as much as they enforce other laws, like immigration, which is great that they're doing more on that, but they need to enforce the laws against illegal secrecy and obviously alerting people to the fact that it looks like President Trump's team, if not President Obama's team, if not President Obama himself, abused the powers entrusted to him in terms of the ability to surveil people. And this is just something that is just astonishing to me. So, of course, what's the media's response? And what's the left's response? To attack Congressman Nunes for coming out and exposing this. So a congressman does the right thing, exposing government corruption, and he's attacked by the media. That just shows you the hypocrisy of what's going on here and why it is you need independent groups like Judicial Watch just keeping on pushing this, because the media isn't going to get to the bottom of it. Because they evidently hate Trump so much that they're allowing, they don't care if a prior administration wiretaps him. However, specifically, whether it was his phones or whatever, but there was surveillance of President Trump. And it's been confirmed, it was inappropriate and it was illegally leaked. I don't know what else you need for a grand jury or a criminal investigation to get going on this. On a related matter, speaking of illegally handling classified materials, we sued this week over Hillary Clinton's mishandling classified emails. And now you don't know this, but you may not know this, but under the Intelligence Community Directive 732, but essentially there's a rule and law that requires the intelligence community to do a damage assessment, quote, when there is actual or suspected unauthorized disclosure or compromise of classified national intelligence that may cause damage to U.S. national security. Now you may recall we asked for that damage assessment to be done in a letter to the Office of Director of National Intelligence, then Mr. Clapper. And I think there's an interim person there now until the President's nominee, Senator Coates, becomes Office of Director of National Intelligence. But they're required to do this damage assessment. And you can imagine why the Obama administration didn't want to do the required damage assessment of the violations of law or the violations of the rules about mishandling classified information was exposed by Hillary Clinton. I mean, this is what Mr. Comey said in July of last year. From a group of 30,000 emails returned to the State Department, 110 emails and 52 email chains have been determined by the owning agency to contain classified information at the time they were sent or received. 8 of those email chains contained information that was top secret at the time they were sent. 36 chains contained secret information, and 8 contained confidential information. Now, all that, that's all just secret, top secret, whatever you want to call it, confidential. Information like that is the information, if it gets out, it's likely to harm our nation's security. And the level of harm denotes the type of information it is, secret, top secret, etc. But they never did a damage assessment. Now, how do you know whether to prosecute someone for doing something wrong if you don't know what the damage is? Maybe no harm, no foul. But if there was harm, certainly there needs to be an accounting for that. Certainly we need to know if there was harm so that we can take steps to mitigate the harm. And it's really outrageous the Obama administration didn't do this. I hope this lawsuit against now the Trump administration, they'll see that, hey, yeah, Judicial Watch is right on the law and we're going to do it. And we hope we don't get the typical fighting we get from the bureaucracies on this. But we're pursuing this lawsuit, and we're not giving up on this. Hillary Clinton violated our national security laws, and believe you me, this attack on Trump on the Russia issue is as much a way to protect Hillary Clinton as it is to go after President Trump, because they know there's still legal liability for what she did, and it ain't over yet. So a lot going on there. We had another good lawsuit this week, and you may not know about this issue, but it's another government scandal, an Obama administration scandal. So there's all this, you may have followed the student loan program. When Obamacare was created, passed into law, part of the Obamacare law was the nationalization of student loans. The federal government essentially took them all over. And as you might imagine, that was an opportunity to start harassing favored or disfavored interest groups, namely for-profit universities. And the argument was that for-profit universities had significantly higher default rates and that students weren't paying back the debts that were much higher than so-called nonprofit universities. Well, it turns out the government had been cooking the books, and there was no difference between more or less between for-profit and nonprofit universities. In fact, according to what we uncovered, or what was uncovered by just one person looking at the documents, and we followed up with a litigation to find out what went on because the government didn't want to tell us what was going on, a coding error had made it seem like the large majority of students were paying back or paying down their debt, when in fact the truth was less than half were. Now that was a big lie the administration had been telling us, that if you go to regular universities, students are paying off their debt appropriately, and the Americans aren't really put on the hook as a result. Well, that wasn't the case. So we asked for records about this coding error that was convenient in terms of helping the Obama administration's radical agenda to shut down for-profit universities. Because the argument is, well, so for-profit universities, the students are getting too much debt, they're not paying it back fast enough, so therefore we're not going to make student loans available to them, and as a result, some of them have had to close. Well, all that was based on, quote, a coding error. And isn't that convenient? And we're trying to find out the truth behind that. So that's an interesting lawsuit. This week I testified. I think I testified just, what's today? Friday? I testified yesterday morning, how quickly things move, to the House Government Reform Committee on transparency. And I highlighted, and I was happy to testify under oath, and to call out the Obama administration as being an enemy of transparency, and calling on President Trump, as you know, to institute a transparency revolution. There's some legislation before the House to open up more government. There's an audit to Fed bill, and there's a bill that we're interested in related to the Fannie and Freddie Mac issue. Now, you may remember Fannie and Freddie cost taxpayers about $187 billion. The government had to take those entities over, and one way they escaped oversight was by giving out political donations to favored politicians like Barack Obama. So we asked for those records once the government took those agencies over, but the Obama administration in 2009, as one of its first decisions, said that none of those records were subject to FOIA. And unfortunately, the court, I won't get into the detail about why they were wrong, but the court unfortunately upheld their views. But it's going to take legislation to undo this, because these agencies guarantee $5 trillion in debt. They control many of the mortgages here in the United States, either directly or indirectly by insuring them or holding them directly. And so these trillions of dollars in public debt, and they also provide now revenue to the government for billions of dollars in revenue, and wholly owned by the government. But we can't get one document out of them. Not one document. So you can get documents from the CIA, the NSA, State Department, you name it, but you can't get any documents from these mortgage monsters that are fully paid for with your tax dollars. And so we're happy that Jason Chaffetz is pushing this bill, and I did testify about that. I testified about the Clinton emails. I had some good questions about White House visitor logs, which need to be made public. President Trump hasn't done that yet. He should start doing that as President Obama did. Now, they should be made public under FOIA, not voluntarily as President Obama did, but that's another matter. And I also talked about the IRS scandal, where we just uncovered new IRS documents that hadn't been given to Congress. So it was a great opportunity to testify to Congress. It's an honor to do that on behalf of Judicial Watch. I know I'm talking for all of you. We have over 500,000 active supporters. And so when I'm going up there, I know, or at least I try to understand and go up there with the idea that, hey, I'm talking for our supporters. And what would they want to tell these members of Congress if they had the chance? Now, I can't say everything I want to say, because it is a controlled committee hearing, but I'm happy to talk about our issues, and it's great to be able to talk about our issues to Congress, because they want to hear about us. They want to hear about it directly from us. And they were very interested. Democrats, I mean, when I started talking about Clinton emails, you should have seen how wide the eyes got of the Democratic members on the committee there. And some of their questions were quite good. You know, transparency is a nonpartisan issue. We have to understand that. Democrats and Republicans, when they're being honest, they like the idea of transparency, and many of them do genuinely want it. But obviously the proof is in the pudding. I also called on FOIA, the transparency law, to apply to Congress in part, and to the federal judiciary. You may not know that, but it doesn't apply to Congress and the judiciary. So it was fun to be able to tell them that these FOIA laws often also have to apply to them. So that was a good opportunity for Judicial Watch, and we'll see what else happens there. Now, Jason Chaffetz is going to be here next week at Judicial Watch's offices. Those of you who are wondering where this is always taking place, this is my office in Judicial Watch's headquarters in Washington, D.C. You know, there's the window there, that lettering is I think that's the preamble to the Declaration of Independence, isn't it?
I think so, yeah.
Yeah, I think so. And so he's going to be here down the hall in our offices. We should be broadcasting that video live next Thursday, March 30th. I'm not sure of the time, but you go to our website and we have information up, and I'm sure it's posted at Facebook. So a lot going on there. And other big news this week, obviously, is the health care bill. I don't know what's going on the Hill, whether the repeal replace bill that the Republicans are offering is going to pass. As best I can tell, it's not a repeal of Obamacare. So I don't know what the fight is, that if you are against repealing Obamacare, you're for Obamacare, which is what I'm hearing from the Republican leadership, including, unfortunately, the president. One thing it doesn't do, which is specifically to Judicial Watch, we had sued over the illegal benefits Congress was getting for Obamacare. So what's happening is Obamacare staff and members are participating on a small business exchange here in the Washington, D.C. Small Business Exchange, the District of Columbia. And they're not allowed to. They have to participate as individuals in the system. They don't want to do that because they would lose their tax-preferred premium support. Because if you get employer-paid insurance premiums, you don't have to report that on your taxes. That's money to you that's not reportable as income. Well, they'd have to pay it out of their own pocket. So Congress, the last Congress during the Obama administration, conspired to allow them, Congress, to participate on a small business exchange. And we got the form showing that Congress signed the form saying that they had less than 49 employees or 45 employees, whatever the number was. Well, Congress has 20,000 employees. So on top of getting the illegal subsidies, they're fraudulently participating in the exchange and signed fraudulent documents. So remember that. And they're not fixing any of that in this legislation. So I'm not going to tell how anyone should vote on any particular legislation, especially complicated things like this. But I do know that the illegal, corrupt Obamacare subsidies for Congress are going to continue under the legislation that everyone is arguing about today. So we're suing about that. We're still waiting on an appellate court hearing here in an appellate court ruling here in the District of Columbia. We sued on behalf of a taxpayer who said, wait, D.C. taxpayer funds can't be used to give something illegally to Congress. So we've got that issue before the courts now. And this is what I love about Judicial Watch. When there's wrongdoing, we try to think of ways to address it through our innovative and cutting-edge litigation and investigation. And Congress doesn't want to talk about this. They're not going to investigate themselves. And the administration, they haven't called Congress out on this issue yet. I hope they do. So it's going to be up to little old Judicial Watch to do the work. So I hope you support us. I think now there's a button on our screen here to allow you to support us directly if you're not already. But either way, thanks for joining us, and we'll see you next week give you some highlights of Chairman Chaffetz's presentation to Judicial Watch next week. And I know we're going to have some IRS news for you, and we're going to have some Clinton email news for you next week as well. So I'll see you around. Thank you.